required to, but you may take notes during this trial, except during the opening statements and closing arguments. The court will provide you with the materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. Transcripts not available for deliberations. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the trial. The credibility of witnesses. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses, and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness had an interest or a lack of interest in the result of this trial, the witness's conduct, appearance, demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during a trial which tend either to support or discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, use your common sense and experience in everyday life. You determine for yourself the reliability of things people say to you. You should do the same thing here. I'm going to give you the elements of first-degree intentional homicide. First-degree intentional homicide, as defined in Statute 940-01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. The state's burden of proof. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. The elements of the crime that the state must prove. Number one, the defendant caused the death of Julie Jensen. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Julie Jensen. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something, while motive may be shown as a circumstance in aiding to establish the guilt of a defendant. The state is not required to prove motive on part of the defendant in order to convict. Evidence of motive does not, by itself, establish guilt. You should give it the weight you believe it deserves under all the circumstances. Burden of proof, presumption of innocence. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Presumption of innocence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The state's burden of proof. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. Reasonable hypothesis. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The meaning of reasonable doubt. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Opening statements. The lawyers will now make their opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, opening statements are not evidence. With that, is the state ready to proceed with their opening statement?
Yes, Your Honor.
Go ahead, Ms. McNeil. Go ahead.
I'm just waiting for your notice.
Like I said, we'll wait.
This is Julie Jensen. She's with her two sons, David, the older boy, and Douglas, the little boy. As you are aware by now, in this case, Mark Jensen, the defendant, stands accused of murdering his wife, Julie Jensen, in 1998 by poisoning her with ethylene glycol, the main ingredient in antifreeze. Now, when you have a murder case such as this, you hear evidence in great detail about the person who is killed. So you're going to hear evidence about how Julie's body was discovered dead in her bed at her home. You'll hear detailed evidence about things like how her arm was positioned, the lividity of the blood in her body, how her face looked buried in the pillow. You're going to hear about Julie's blood and what was in it, her stomach contents and her kidneys, and how they revealed the evidence of the ethylene glycol poisoning. And there's two things that you're going to hear in the evidence that you should know about ethylene glycol poisoning. A person should not have ethylene glycol in their system. The human body is made up of all sorts of things, but ethylene glycol is not one of them. So if ethylene glycol is found in a person, that is instant evidence of poisoning. And it has happened that some people have accidentally killed themselves with ethylene glycol, and some people have purposefully committed suicide by drinking ethylene glycol. But in this case, the evidence you're going to hear is that the defendant murdered his wife with ethylene glycol, that this was not Julie Jensen ingesting that substance to commit suicide. And that leads me to the other thing you should know about ethylene glycol. It's a drug that is not commonly tested for at autopsy. At autopsies, there are tests that are done for drugs, like prescription drugs or illegal street drugs. But ethylene glycol, such an unusual substance, is not typically tested for. And so a person doing an autopsy isn't necessarily going to find it unless they're looking for it. So you're going to hear that evidence about the ethylene glycol in Julie Jensen's blood and in her stomach, and other evidence of that poisoning in her system. You may even see some photos from the autopsy showing evidence from the inside of her body. So in this trial, you're going to hear Julie Jensen talked about in that way, that detached, impersonal evidence. But this is Julie Jensen. And in this murder case, even more important than how her body was found and what was in her blood and her stomach, even more important than that is the evidence you will hear about Julie the person. You are going to hear from witness after witness, people who knew Julie in various aspects of her life, that her family and her children were everything to her. She even had a specialized license plate on her car, My 3Ds, that stood for her two children, David and Douglas, and the father of her children, the third D, Daddy, that was for Mark Jensen. When Julie Jensen died, her oldest son, David, he was 8 years old. He was in 3rd grade at Southport Elementary School. And you are going to hear from David's 3rd grade teacher. Her name is Therese DeFazio. And she's a witness in this case because Julie Jensen was very involved in her son's life. She was actually a room mother in this 3rd grade class. And so even though her youngest child, Douglas, he was only 3 years old, and she was a stay-at-home mom, it doesn't mean that she just stayed at home. Every Wednesday morning, starting in the beginning of that school year in 1998, Julie would volunteer in David's classroom to help out Ms. DeFazio. She would help the other students in the class and help Ms. DeFazio with various projects. And one thing that Julie Jensen and Ms. DeFazio had in common that you'll hear about in the evidence is that Ms. DeFazio had 2 sons too, 2 older sons. And so that was a topic of conversation between them because Julie Jensen was asking her for advice. What do you do with 2 sons? How do you raise your sons? She was looking towards the future, thinking about college for David, a very bright child. And Julie Jensen was also a big part of her children's activities. She was the kind of mom who would make Halloween costumes for her kids by hand. She was good at crafts and sewing, and she was a good baker. And you're going to hear in this case a lot about the neighborhood. The Jensens lived in Pleasant Prairie in a neighborhood known as Carroll Beach, which is near the lake. They had a nice yard with a beautiful garden, a swimming pool, and you'll hear from the neighbors who often saw Julie playing in the yard with the children or neighborhood children coming over to the house because they had the swimming pool. But Julie Jensen also had a life outside her children. Before her oldest son was born, she worked as an assistant at a stock brokerage firm. And even when she was a stay-at-home mom, she wasn't an isolated person. She was outgoing. She went out of her way to meet and get to know her neighbors. She made her neighbors her friends. And you're going to hear from a variety of neighbors who say that about Julie Jensen. She was also active in a neighborhood book club. You're going to hear about the book club. The month before Julie Jensen died, in November of 1998, she hosted the book club and she invited the ladies in the book club into her home. Finally, she was an avid gardener. Gardening was really her passion, so she would be outside a lot working on the garden. In the week of her death, she called a neighbor just to discuss gardening, some seeds that the neighbor had or had grown. Julie Jensen was looking to purchase that in the future and was asking questions about it of her neighbor. The only real problem for Julie Jensen in the fall of 1998 was with her marriage. But before we talk about that time, the fall of 1998, I want to go back to 1990 and to 1991, in the months after David, her oldest, was born. Now, that's a big transition time in a marriage, the time before kids and the time after kids. And it caused some issues in the Jensen marriage. Julie felt that the defendant was not involved enough with David, not supportive enough. And she had returned to work part-time after David's birth, and that was a difficult transition too. And Julie Jensen during that time was suffering from some postpartum depression. And she went to a psychotherapist. She saw the psychotherapist for about a year. She was prescribed an antidepressant. And the defendant also went to the psychotherapist several times too, because the therapist felt it was useful to see both the Jensens, and these sessions lasted about a year. So in this trial, if you hear about Julie Jensen's history of depression, that this is a suicide because she had a history of depression, well, that's it. The postpartum depression and seasonal affective disorder when the seasons change, like fall, that she was treated for 1 year in 1990 to 1991. Julie Jensen did not have a history of suicide attempts. She did not have suicidal ideation. She had no suicide plans. And what a therapist is supposed to do, what you'll hear in the evidence, is ask someone, if they have signs of depression, to ask that person about risk of suicide. At no time did Julie Jensen ever say she was contemplating suicide. And in fact, she would cite her children. She could never do it because of her kids. And that's what happened in 1990 and 1991. And really what you're going to hear is the problem during that time period was with the Jensen marriage. In addition to Julie Jensen's concerns about the defendant's lack of involvement with David, she just felt the defendant didn't love her anymore. And she even contemplated divorce during that time period. Julie Jensen began confiding in a coworker, a man named Perry Tariqa. He was going through a divorce and he also had a young child. And one weekend, Julie made the mistake of inviting Perry Tariqa to her home on a weekend when her husband was gone. And that weekend, she had sex, she had a fling with Perry Tariqa. So she cheated on her husband. Now that's the only time Julie Jensen and Perry Tariqa were intimate. And you can tell from the evidence that Julie Jensen immediately regretted this. She cut off the relationship with this man immediately. And she even left her employment where they had worked together. And after that, Julie Jensen decided to not keep secrets from her husband again. And in this trial, I expect you'll hear from Perry Tariqa as a witness. I expect you'll hear about this relationship he and Julie Jensen had as co-workers at first, and then confiding in each other about their more personal issues. And you'll hear about during that time period, as Julie was contemplating divorce, she even went with Mr. Tariqa to his divorce lawyer. And in fact, in June of 1991, Julie Jensen did file for divorce, though obviously that didn't go through. The reason I am going back to 1990 and 1991 is because that changed everything in the Jensen marriage. You will hear in the evidence that the defendant never forgave Julie Jensen for that affair. And by the way, there's no obligation to forgive a spouse for an affair. That's not required. Sometimes affairs break relationships, they break marriages. When that happens, divorce is always an option. Forgiveness is not required. But Mark Jensen did not file for a divorce. Instead, he engaged in a campaign of covert harassment directed at his wife to degrade her and gratify him. In a case that is full of strange facts, this harassment over the course of years is perhaps the strangest. And here's how it would look. From time to time, starting after Julie's affair, someone would apparently be leaving pornographic images outside of the Jensen home, on the deck, in the shed, even, allegedly, mailing these pornographic images to the defendant's place of work and leaving them on his car at work. And so what were these images? Well, almost all of them appear to be printed out computer photos, so in black and white, on regular paper. Only once was it an actual photograph that was left.
Every single morning, I take a cannabis gummy and go for a walk.
Pornographic, they would show sexual activity. Sometimes sexual intercourse, sometimes oral sex, sometimes a woman positioned as though she was about to perform oral sex on a man, and sometimes just naked photos of men with erect penises. Another feature of this harassment was phone calls. Far more than the occasional hang-up call that people got in the 1990s, over and over and over again, call after call of hang-ups. And a lot of this was directed towards Mark, he said, that he would get these harassing calls at work, that he would receive these harassing photos at work. And so over and over and over again, Julie Jensen reported this activity to the Pleasant Prairie Police Department, beginning in 1991 after that affair, and all the way through the beginning of 1998, this continued. An extremely long length of time, almost 7 years. And this happens so frequently, and Julie Jensen reported it to the police, that she actually asked to just speak to one officer, so she wouldn't have to say the whole story over and over again. And that officer ended up being Officer Ron Cosman. And so how it would work is, most of the images were purportedly found by the defendant. That's what Julie told the police. The defendant would come to her and present her with the images he had found at work or at home, and as the Jensens reported it to the police, they believed the culprit was Perry Tarica. Because it seemed as though the images were chosen to resemble Julie. And the frightening idea was presented that this man, Perry Tarica, had secretly taken pictures of him and Julie when they had sex that long time ago. That he had had this fling with Julie, and now he was rubbing it in her face to humiliate her for years. And the police tried to investigate this. The police suggested to Julie that she keep a log of this activity. And you're going to see that she did. She kept a handwritten log. And it's actually stunning to see because it's so long. There's just page after page of this harassing activity. Because the defendant had said that these images were frequently left at his vehicle at work, the Pleasant Prairie Police Department suggested that the Jensens hire a private investigator. Maybe that person can stake out the car and see if they catch anybody. Or they suggested placing a video camera, videotape the car, and see if anyone leaves anything. But these efforts didn't work. The defendant was aware of this private investigator, and so while that private investigator was involved, nothing happened. The police also suggested putting a trace on the phone through the phone company. Remember, we're talking about the 90s, and so no caller ID. But when these traces were put on, the calls would stop. So the anonymous perpetrator could not be found that way. And so Officer Ron Cosman, he had a lot of contacts with Julie about this because of the harassment, and he was thinking about these traces, and he was thinking, well, how could these phone calls stop when we try to put these traces on? How could the perpetrator know to stop these calls? The only people who know about these traces are the Jensens and me, the police officer. And so Ron Cosman specifically asked Julie, for the last trace that was done, he asked her not to tell the defendant. And so when the last trace is put on, and Officer Ron Cosman is checking in on that, and so he goes to Julie's house and he asks her if the calls had continued, and she said no. But Julie wasn't looking him in the eye. And so he asked her, did you tell the defendant this trace was going on? And she admitted that she had. And at that moment, Ron Cosman was frustrated with her. He said, why'd you do that? And so Julie explained, remember, in her mind, this harassment is her fault. It's because of that affair. This degradation, what her husband is going through, what she's going through, it's her fault. And she said, well, after that affair, she just didn't want to keep things from the defendant. Didn't feel right not to tell him, so she told him. And it's true that the man that Julie Jensen had this affair with, he was a suspect too. But the thing is, he had never even lived in Wisconsin, and then even living in Illinois, he ended up moving away, far away, like you'd have to fly a plane. He ended up moving far away early on. And this harassment, again, went on for like 7 years. And so it just didn't make sense. He's coming back to Wisconsin to leave these pictures around the Jensen home. It's not even a drive away. To leave these pictures at Mark Jensen's place of work, it just doesn't make sense. So you're going to see in the evidence this log that Julie kept of this harassment. And Julie Jensen ended up dying. She died on December 3rd of 1998. But this virtually constant harassment that had been going on since 1991, it slows down after June of 1998, and then it comes to a total stop after August of 1998. And you're going to hear in the evidence in this period of time that that's when the defendant gets a girlfriend. That's when his affair starts. Now, you're also going to hear about computer evidence. And most of the computer evidence relates to the murder itself, but some of it relates to this harassment. And one thing you'll hear is that the defendant, on his work computer, which was seized by the police, this is a 2002 computer. So years after the harassment, but it's still relevant for this reason. On this 2002 work computer, the defendant had an extensive collection of pornographic images.
Judge, I object at this point. I'd ask for 5 more.
Let you guys go on back for a second. We're going to just take care of it right away.
Images of pornography, unless they can somehow be connected to the images that were dropped around the house or around the work. I'm not sure how that's relevant. It's years after Julie Jensen's death, and unless there's a direct connection, a computer he had after her death, I don't know how that's relevant or those images would be relevant.
Your Honor, I'll just say this. I think it's outrageous that Ms. McNeil's opening statement was interrupted by this. Defense counsel has known for years that this evidence had been admitted at the last trial. If it was defense counsel's intention to bring a motion to exclude this evidence, that motion should have been heard by this court. We had numerous pretrial motions. There's never been any question that this evidence was going to be admitted during the course of this trial. And this evidence is clearly critically relevant to the evidence the state is going to be presenting during the course of this case. These 2,200 penis photos that were on the defendant's computer demonstrate a number of things. It demonstrates his odd preoccupation with the male member. It demonstrates that his level of offense that he took, that his wife, Julie, had this affair with this Perry Tariqa, in which she had apparently performed fellatio upon Perry Tariqa, but it was something that she wouldn't do with him. These Venus photos that were left around the house for years and years and years, according to the investigating officers, including a Detective Ellis, who was a private detective in this matter, reflected that somebody had an enormous array of pornography that they could tap in order to find penis photos that included a person that kind of looked like Julie, and included a background where they could not exclude her bedroom as being the place where these photos were taken. There was ample testimony about this at the last trial. The relevance of the other act's evidence has already been ruled upon by the Wisconsin Court of Appeals, and it's the law of the case in this matter. So to interrupt this opening statement on this basis is outrageous, and the objection should be overruled, and we should continue with this opening statement.
I'll let you respond briefly.
Thank you, Judge. I have to object when I think there's irrelevant, inadmissible evidence being presented, and I'm going to continue to do that during witnesses, even if they testified about it last time, because this court decides what's relevant in this case. Unless they can connect these 2002 penis pictures to the evidence prior to 1998, I don't understand how it's relevant. If the pictures that the Jensens were receiving were of someone giving fellatio, and these are just penis pictures, again, I'm not sure how it's relevant to the death of Julie Jensen.
All right, what I'm going to say is the last statement by Ms. Krause would be a great statement and a closing argument, because we would have had all the evidence come in, and if the defense had made a motion on relevance and I had overruled it, the defense could argue, well, even though it came in, we don't think it's relevant. We're at opening statements. This is not my first rodeo. I don't see a lot of objections at opening statements. And a lot of times, statements are made, and then it comes back to haunt the other party because that evidence was never presented, it never came in. So, I just read to the jury, opening statements are not evidence. They're an opportunity to tell you what the evidence will show. And if the state wants to bring in this evidence, I'm not going to prejudge every little bit of statement that's being made now and rule whether it's relevant or not. We're going to be here for 3 years, not 5 weeks. So it's not a good objection.
I understand, Judge, and I will.
You have a right, but it's not a good objection. I want it noted for the record. Bring the jury back. Ladies and gentlemen, thank you for your patience. We are back on the record. All right, we're back on the record on the Jensen matter. The jury has returned to the courtroom. The appearances are the same. Thank you for your patience. I'm going to overrule the objection, and the state can continue with their opening statement. Go ahead, Ms. McNeil.
So these 2002 images on the work computer, they're relevant because it shows that the defendant had an extensive collection of pornographic images that were categorized and were similar to the harassing images that were left around the Jensen residence over that period of time. And I describe those images for a reason, because they connect to these 2002 images found on the defendant's work computer. But that's in 2002. So let's talk about 1998. What you're going to see here is you're going to see an example of Julie's log, what she kept, what she hand wrote about this harassing activity. You'll see the date at the top there, January 19th of 1998, and what Julie Jensen described as new tactics live on the internet. And so she's describing this harassment that is apparently occurring now with a change of tactics over the internet. And then what I want to show you next is what is noted on April 13th of 1998. Julie Jensen notes in this log an email that's part of the harassment. Here's the email. You'll see that it's from someone by the name of Turtle, that's the name in the email, to Mark Jensen. And then you'll see in the text of the email, consistent with the harassment, here's a few for Jay, so Julie, of me soft. Also a shot I took without her knowing it of a married girl in the office I'm currently doing at a nearby hotel. Attached to this email are 3 pornographic images of nude males, and then what looks like a surreptitious image taken of a topless woman in a hotel room. And it's consistent with the harassment because here's this harasser suggesting essentially he's doing it to another woman, taking pictures of her secretly, which was the same implication given to Julie Jensen in the course of this harassment. And then also, again, of course, the pictures of a nude male. This email is from mjensen@execpc.com to mjensen@execpc.com with the names changed. So the way you would see this email in 1998, it would just look like it's from an anonymous person named Turtle to Mark Jensen. But the way our computer analysts can see the email, our computer analysts can see who it's from. It's an email the defendant sent to himself, pretending, under disguise, to be, he's acting as the perpetrator of this harassment. So how do we know Mark Jensen is really the harasser? A variety of things, but this email proves it. Where else do we see the email? We see the same email address show up on the Jensen home computer. This email address, mjensen@execpc.com, is in the Jensen home computer under the name Mark Jensen. So, this harassing, degrading email that's noted in Julie's log was sent by Mark Jensen to Mark Jensen under the guise of the harasser to be presented by the defendant to Julie as continued punishment for her affair, now, years later, in the spring of 1998. So that's the evidence that you're going to hear, that the first time the Jensen marriage was on the rocks in the early 1990s, that Julie Jensen sought counseling and treatment. She was treated for depression. She seriously contemplated divorce and even filed for divorce in 1991. In contrast, Mark Jensen engaged in a years-long covert campaign to harass and punish his wife. So let's turn to what's happening in 1998 when the Jensen marriage was again crumbling. In 1998, Mark Jensen moved jobs. He was now working as a stockbroker at a company called Stiefel Nicholas. The home base for that company was in St. Louis. And working in St. Louis, is now working as a stockbroker at a company called Stifel Nicolaus. The home base for that company was in St. Louis. And working in St. Louis as an assistant to the defendant's boss was a woman by the name of Kelly Labonte. In this case, Kelly Labonte is sometimes referred to as the motive, because the defendant began having an affair with her in around September of 1998. And this was a very serious relationship, because shortly after Julie Jensen's death, just in the weeks after, Kelly Labonte would come to Pleasant Prairie to visit. She would stay at the defendant's house. Soon thereafter, she moved to Wisconsin. She remained in a relationship with the defendant for years after Julie's death. She married him. She had a child with him. And they were together until about 2009 when they divorced. And part of this evidence, an important part of this evidence, the computer evidence, right here, you can see in this picture in the back here, that's the home computer. A picture of the Jensen home computer in their home in 1998. And so because we're talking about 1998, we're talking about not a laptop or something mobile. We're talking about a desktop computer that has its own room in the Jensen residence. This isn't in a bedroom or a room that's occupied for people for other reasons. There's no TV. This is the computer room, essentially. And what you're going to see is that on this computer, after it was seized by the police, the day of Julie's death, on this computer, the police found emails between the defendant and Kelly Labonte. Now, these were work emails in the sense that what the defendant was doing is he was accessing his work emails from home, which now is pretty normal to do on your cell phone or on your laptop. But back then in 1998, with dial-up internet, that was pretty sophisticated. And you're going to hear the detective in that time frame didn't even fully understand it. How are these work emails on the home computer? But that's how they were accessed. And so the detective sees these work emails, but he sees they're not just emails between coworkers. These emails are full of sexual innuendo, and it's obvious that these people, during the fall of 1998, they were in a relationship. They were having an affair, because Kelly ended up getting married too in that time period. In fact, in one of these emails from October of 1998, the defendant refers to Kelly Labonte as his girlfriend. And they end the emails frequently, almost all the time, with I-D-L-Y. I do love you. So within a few months after Julie Jensen's death, the police are aware of this affair, the motive. And the detective sits down with the defendant in April of 1999, so a few months after Julie's death. And as this investigation is continuing, the detective, who has seen these emails, asks the defendant about Kelly Labonte. And the defendant lies. He says, before Julie's death, they were just co-workers and friends. He had only seen her a few times. They weren't in a relationship. And even at that point, in the spring of 1999, he wouldn't describe them as dating. It's a lot of hemming and hawing about what he wanted to call them. And he certainly didn't want to admit to having this affair. Now, in this trial, I expect the undisputed evidence is going to show that the defendant was in the midst of an affair with Kelly Labonte when he killed his wife, Julie. Now, Julie was a perceptive person, and in the fall of 1998, she noticed changes in her husband. She knew that something was wrong. Something had changed after her husband had started this new job at Stifel Nicolaus. And she even suspected that maybe there was another woman, maybe her husband was having an affair. But the proof that the police had found was on the computer. And a critical part of the evidence that you're going to hear in this case is that Julie Jensen didn't know anything about computers. Now, nowadays, that sounds almost impossible in 2023, but life was different in 1998. People did exist without computers. They had grown up without computers. If you were an adult in 1998, you'd grown up without a computer. You started your work life, no computer. No one had these little computers in their pocket. And the internet itself was in its infancy. This is dial-up internet. You can probably hear it when I say the words, hear it yelling at you. And so what you're going to hear in this case is that this internet, this incredibly slow internet, this is something that Julie Jensen never used. You're going to hear that Julie Jensen didn't have an email address. There's no evidence of her sending an email. you'll see that this computer evidence, that computer in the Jensen home, the internet was only used on that computer during times when the defendant was home. And Julie was a stay-at-home mom, so she had access to this computer all day long. But the computer analyst can tell when the internet was being accessed, the times. And they can tell that when Julie's home alone, no one's using the internet. It's only when the defendant is home, late at night, the early morning hours, when it's used during the daytime, it's on a weekend. Those are the times the internet is being used on this computer. And you're going to hear that there's also several documented times when we know from the evidence the defendant was out of town. There's no internet usage during those times. Julie Jensen did not use the computer or the internet back in 1998, when that was actually possible. You're even going to hear an anecdote from Therese DeFazio. Remember, she's the third grade teacher. You're going to hear that when Julie Jensen came to her classroom and offered to volunteer, Therese DeFazio thought, oh, it might be helpful, maybe Julie can help the kids in their computer lab. And so Therese DeFazio suggested that, and Julie was like, oh no, I don't even know how to turn on a computer. You know, Julie wanted to be helpful, but she told Therese DeFazio way back at the beginning of the school year, I really can't help with the computers. I can maybe type if someone opens a program for me, but that's it. So with proof of the defendant's affair being on the computer, Julie didn't have proof, only suspicions. She and her husband were arguing all the time, and she said when the defendant wasn't arguing with her, he basically didn't speak to her at all. Their relationship in 1998, that fall, was just falling apart. And once again, as in 1990, 1991, Julie was contemplating divorce. Now, during this time period, there were a few people that Julie Jensen confided in. Particularly, you're going to hear these names a lot, particularly her neighbors, Margaret and Ted Voigt. Now, I call them Julie's neighbors, but you're going to see in the evidence that they were really more than neighbors. They were friends. They had lived next to each other for years. The Voigts also had 2 children who were growing up. They both spent a lot of time outside. The Voigts' children would come over to play in the pool. They would see Julie outside all the time, working on the garden. They would socialize with each other. They went out to dinners. They went to places like Six Flags with their kids. They went to the zoo or birthday parties, so they were friends. They were more than neighbors. In fact, you're going to hear in the evidence that Julie Jensen saw the Voigts so commonly that it was basically every day. Virtually every day, they'd see each other and chat with each other. So one day, about 5 or 6 weeks before Julie died, in about late October of 1998, Ted Voigt saw Julie Jensen in the front of her house. There was a bench there, and she was sitting there and she was crying. And Ted Voigt was getting ready for work that morning, but he saw his friend, his neighbor, crying. And so he went over to her. And this is the first of a series of conversations that Julie Jensen had with Ted Voigt about her concerns about her marriage and what was going on with the defendant. You'll hear about these conversations in detail in the evidence, but basically over the course of these 5 or 6 weeks before her death, Julie Jensen told Ted Voigt about the arguments with the defendant, how the defendant seemed changed, her worry that maybe the defendant was having an affair, and things that Julie had noticed with the defendant about the computer. She talked about going by the computer and seeing sticky notes that he had written by the computer that were suspicious, that had weird words on them like syringe and names of drugs. And she saw the defendant on the computer. For instance, she'd be vacuuming in the hall outside, and she saw on the screen that he was looking up poisoning and then closed the door in her face. She described another time when the defendant had gone to work but left the computer on, and on the screen there was a website about poisoning. So now, moving to late November, I'm going to put up here a calendar that'll help you with the days. Moving to late November and the days before Julie's death, which happened on December 3rd, Julie confided in Therese DeFazio. And this was the last time she saw Therese DeFazio. And you'll hear Ms. DeFazio recount this conversation and how she saw that Julie was troubled and encouraged Julie to speak to her. And Julie told Ms. DeFazio that she was afraid that her husband was going to kill her. Now, Ms. DeFazio was shocked and she was taken aback, and she asked Julie why she would think something so serious. And Julie explained about that list, that weird sticky note, And then she explained that she feared that her husband might try to kill her with a drug overdose and make it look like a suicide. Again, Ms. DeFazio asked her why she thought her husband might do this, and Julie said there were other things that she couldn't explain. And Julie confided to Ms. DeFazio, the same as she had to Mr. Voigt, that it bothered her how every time she walked by that computer room and the defendant was in it, he would cover it or turn it off quickly so she couldn't see the screen. And then there's a third person, the defendant's sister, Laura Coster. During Julie's life, Julie and Laura Coster were good friends. So even though Laura Coster is the defendant's sister, Julie confided in her as a friend. Julie Jensen spoke to the defendant's sister about the same suspicious note, the one that listed the syringe on it, and she even told the defendant's sister. She told her in the fall of 1998 that she feared that the defendant might be planning to kill her.